penis actually went inside, and she experienced a great deal of pain at that time in the area of the vagina. And there was an abrasion of the labia minora, which would make that, and I think the case stands for the fact that if there's penetration or some kind of penetration into the area of the labia minora, that is sufficient evidence of penetration. But there was testimony to show that penetration of the vagina to a physician would require an entry into. The point is, in this court's view, there is simply not enough evidence for penetration. There is enough evidence for sexual contact. People against Kobe Ferguson. This is file number 25B728-899. Your appearance, everybody?
Good morning again, Your Honor. Madison Oro on behalf of the people, PA8398.
Mr. Martell?
Thank you, Judge. Good morning, Your Honor. Good morning to your fine staff. May it please this most honorable court, Edward Martell, P85051, on behalf of Kobe Ferguson. Young man, state your name for the record.
Judge file. I think it's under there.
Right here.
Mr. Ferguson, if you haven't already, state your name.
Mr. Ferguson, state your name. State your name, please.
Ferguson.
You got to be more clear with it, sir. State your name again. I need your full name.
Kobe Ferguson.
Thank you. All right. So there's 3 counts of CSC. There's 1 count of assault with intent to commit great bodily harm, less than murder or by strangulation. Prosecutor acknowledged that she didn't prove it as to one of the counts. There were only 2 incidents here. Mr. Martell, I'm going to give you your choice. There was no proof of age of the defendant. I'm either going to let the prosecutor reopen their proofs, or if you wish to stipulate that he was born on June 1 of 23, then that's up to you. Whatever you want. If I allow them to reopen their proofs, it's going to be with respect to the defendant's age only.
Judge, we would stipulate to my client's age.
So you stipulate that
to his age only.
September of 25, he was the age of, I'm sorry, as of September of 25, he was 22 years old, correct?
That is correct, Judge.
All right. So for purposes of exam, court will accept that stipulation. I said I wanted to think about this. I did. The testimony provided this, that the victim, whose name I'm not going to mention, was born in May of 2011 and was 15 at the time of these incidents. She attended a local high school in the 9th grade. She became acquainted with Mr. Ferguson. They had 2 different incidents, I should say. He told her that he was 16. She was 14 at the time when they first met. He said he went to Trenton High School, which that turned out to be untrue. But nonetheless, they had 2 sexual episodes in September of 25. They started doing something in the first episode, and honestly, she described her private parts as being her chest and the area from her waist down. She talked about, the prosecutor asked her some questions about what she was referring to. She said she described peeing as being his genitalia, and she referred to hers as that. She said at one time they were both naked. He was on top of her. There was movement, she said, for 4 to 3 minutes. She said the entire episode lasted. The second incident was kind of the same. They were later at a different residence at one of her friends' houses. They were doing the same thing in the bathroom. And somebody knocked on the door saying the food was ready, and they stopped. And she said that was for 2 or 3 minutes that incident took place. There was no testimony or evidence with regard to ejaculation. There was no evidence that there was actual penetration in the court's view. The prosecutor argues that there was, because they were on top of one another, and that there was movement in the genitalia area for 3 to 4 minutes on an occasion, 2 to 3 minutes on another occasion. The prosecutor cited the case of Bristol, and I just find that so different. People versus Bristol at 115 Mish Ave 236. And in that case, the victim was a 4-year-old girl. In response to questioning by the attending doctor, said the defendant's penis actually went inside, and she experienced a great deal of pain at that time in the area of the vagina. And there was an abrasion of the labia minora, which would make that, and I think the case stands for the fact that if there's penetration or some kind of penetration into the area of the labia minora, that is sufficient evidence of penetration. But there was testimony to show that penetration of the vagina to a physician would require an entry into. The point is, in this court's view, there is simply not enough evidence for penetration. There is enough evidence for sexual contact. The defendant was more than 5 years older than her at the time. And I'm simply going to indicate that I'm not binding over on CSC3 because, again, there's just not sufficient evidence of penetration. There is sufficient evidence of sexual contact, but I'm not going to bind over on that count. I'm going to bind over on 755-520E. That person, there's sexual contact in the 4th degree if the person engages in sexual contact with another person, and that person is at least 13 and less than 16, and the actor is 5 or more years older than the victim. So in this case, the age qualifies. I'm not binding over either on the assault with intent to do great bodily harm less than strangulation. Yes, the victim said he had his hand on her neck for about a minute. Yes, she said it got to be uncomfortable. There was not simply enough testimony developed to establish that there was restricted blood flow as applicable in that section that would qualify for that. So I'm simply binding over on 2 counts of CSC in the 4th degree. I'm dismissing all 3 counts of CSC. Wait a minute, let me repeat that. I'm binding over on 2 counts of CSC 4. I'm dismissing all 3 counts of CSC 3. I'm also dismissing the count of assault with intent to do great bodily harm less than murder or by strangulation. Defendant is bound over for further proceedings to the Wayne County Circuit Court. He is not in custody, so we're going to have the AOI on. That would be what, Lisa? The 23rd, right?
Let me double check. Yes, the 23rd.
June 23rd. And let's see
And Judge,
here.
just to clarify, if the parties were not allowed to put, I guess, state their stance, because I wasn't able to argue anything today. I thought that was the purpose of today's proceeding. It sounds like, Judge, you just stated everything that you had already stated last week. But
So
I
let
haven't
you guys
been able
argue
to
last, but
respond to
listen to
that.
me. This was not the purpose of today. I let you guys argue last.
Oh,
Listen
I
to
was-
me. Counsel, you're getting a little too aggressive with me. I don't want to hear this anymore from you or any other lawyer. Sounds like you already made up your mind. I heard that from you 2 or 3 times last time. I told you how I felt about this. The only purpose for me, I said I wanted to go back and review my notes and review the tape. And I told you guys you could submit other cases without having to brief them. I specifically said, I'll be glad to entertain any other cases that you have. And all you have to do is say, Judge, please read so-and-so versus Smith and cite the case. Nobody did that. I didn't receive anything. I heard your argument last time. I told you then I didn't believe there was penetration. I still believe it now. You don't like it? Appeal. But I don't like you arguing with me. And I don't like you telling me last week 2 or 3 times you're a young lawyer, but I don't like you telling me, sounds like you already made up your mind. I made up my mind based on the lack of testimony and the lack of evidence.
Okay, Judge, thank you.
Did I not? Did I? if I didn't let somebody argue, shame on me, but I don't think that was the purpose was to come back and argue.
You-
We'd already covered this. You moved the bind over, he argued, you argued.
You did, Judge, and I
Bonds
think I misunderstood because I think right now you stated to submit the case law, and I think that's where my misunderstanding was. I had case law to argue today, so that's my misunderstanding, and for that I
I
do apologize.
specifically said to you guys, don't come to court with the case law. Send the case law to me beforehand, and the record will reflect that, and I will read it. I wasn't going to burden you guys with briefing anything because I can read.
That's okay, Judge. I apologize. I got that.
I don't mind lawyers disagreeing with me, okay? It's going to happen every single day. I do mind lawyers getting smart with me. And I thought you got smart with me last week, and I don't appreciate what you just said now. What do we have as the bond
Judge,
on
my
this? These were
intention was to
different
not get-
incident dates. Lisa, what do we have with the bond on this case? It looks like Judge Hessen cited a different.
Let me
She-
check. I'm bringing it up right now.
812, it looks like she said 50,000, 10%. But these are two different incident dates. And she just referenced the other one. So unless somebody can tell me something, counsel,
Yeah, there's no bond on that 899
well, I gotta
case.
set one. I'm gonna set one now. So do you have any objection at this point? He's bound over on 25B 725-812. Do you have any objection to a personal bond, Ms. Earl? If you do, feel free to argue it.
Judge, I wouldn't have any objection at this time, though I will say at the time that the other case was in front of Judge Hessen, she did make the bond for both cases the same. I don't know if that's not showing up on the two cases,
Oh,
but she had reflected.
No, I agree with you. She referenced the other case, but he posted the 50,000, 10%. So I'm gonna leave that on the other one, Lisa. I want to make sure the record is clear. There's to be 50,000, 10% on 25B 725-812. And I'm going to set on this case 50,000 personal bond. No contact with the victim or prosecution witnesses not to enter 24591 San Marino apartment 103. No alcohol, marijuana, or illegal drugs. No firearms or dangerous weapons. Not to be within 5 miles of the victim, her residence, or place of employment. No unsought supervised contact with any child less than 18 years of age. Do you understand that, Mr. Ferguson?
I'm referring to where I work.
Wherever you're working in law, in your capacity that requires you to carry a firearm, I'll let you continue to do that. I'm not going to take your job from you effectively by saying you can't use a firearm, but I want you to store it somewhere. I don't want it in your possession except in the course of employment. No contact with him. You cannot write, phone, see, text, email him, communicate with them. People against Robert Joseph MacArthur. This is 26G 709-1562. All right, your appearance.
Your Honor, good morning to you and the staff. Vincent Haysha, with and on behalf of Robert Joseph MacArthur, who's present through Zoom without objection.
All right, Mr. MacArthur, your name, sir?
Good morning, Your Honor. Robert Joseph MacArthur.
Who's this gentleman sitting next to you?
That would be my son, Robert Nicholas MacArthur.
How you doing, sir?
Good.
Co-defendant case, Judge.
What's that?
It's a co-defendant case. I represent both of the individuals.
I think they sent in, oh, they did. Now I also have Robert Nicholas MacArthur, 26G 709-1561. Okay. Your appearance again, Robert Nicholas MacArthur.
Vincent Haysha, with and on behalf also with Robert Nicholas MacArthur, who is present through Zoom without objection.
And sir, your name again?
Robert Nicholas MacArthur.
All right, so they're charged with aggravated assault. For purposes of arraignment, do they stand mute and waive formal reading?
Yes, Your Honor.
All right, now I have some concerns. Let's talk about the first one. What do you think that's going to be? Are you sure there's not a conflict?
Your Honor, I've spoken to both Robert Joseph and Robert Nicholas extensively about the aspect of a conflict of interest, about the typical necessity of having separate counsel, about the potential that conflicts could arise throughout the course of a case. I believe that they both understand and acknowledge that that is, I guess, theoretically always a possibility, but in this particular circumstance, do not believe it to be a possibility that will arise. I don't believe that there's a conflict. I think that they have mutual interests. I believe that their defense is extremely similar, and I don't think that that is something that could arise. I just want the record to be clear that it's a conversation I've had separately with father and son, with Robert Joseph and Robert Nicholas, and I do believe that they're knowingly and understandingly moving forward with the same counsel at this point.
Robert Joseph MacArthur, do you
Yes, sir.
understand everything that your lawyer just said?
Yes, sir, I do.
And do you understand everything your lawyer just said, Robert Nicholas MacArthur?
I do as well. Yes, sir.
So you understand whenever there's co-defendants and a defense lawyer is representing both, that there certainly is a potential for a conflict of interest to arise. One defendant says, I didn't do it, he did it, or anything else similar thereto. That creates a real conflict of interest issue. Do you understand that, Robert Joseph MacArthur?
Yes, sir, I do.
And Robert Nicholas, do you understand, Robert Nicholas MacArthur, do you also understand that?
Yes, sir, I do.
Knowing all that at this point, based on your consultation with your lawyer and based on what he said, do you want him still to represent you at this point, understanding that he's telling the court if a conflict arises, he will take the appropriate steps to make sure that the conflict is resolved. Do you understand that, Mr. MacArthur? Robert
Yes, sir.
Joseph?
Yes, sir, I
And you
understand
still
that.
want him to represent you?
Yes, I do, sir.
And how about you, Robert Nicholas? Do you still want him to represent you?
Yes, sir, I do.
All right, now that's one concern. The second concern I have here, I don't mind them appearing by Zoom. What I do worry about is there's a necessity for me to get them printed. I mean, this is not, still a 1-year misdemeanor, and that means they're going to have to come here unless you can figure out some other way. Is there a detective on this from Gibraltar out there by chance?
Not on Zoom.
Okay, they didn't my granddaughter, where'd they take her, do you know? John, can you
They-
go in those,
They walked down with her.
can you bring her in here, get her in here, please? All right. So how do you propose that we handle that? They live in Estero Beach. I mean, I don't need them coming back for every proceeding unless there's a trial, but I do need them to get printed.
I understand that completely, Your Honor. I can reach out to Gibraltar and see if there's a way that they can have prints taken out of the state. If it's not a possibility, then they'll have to make arrangements, and I'll communicate with the court, and we'll get that done in a reasonable amount of time, Your Honor. It's not something I considered prior to today, or otherwise I may have had a better answer for you. But I do think if it's something that requires them to travel, then we'll make sure that they travel and make appropriate accommodations.
I'm surprised nobody from Gibraltar's here on this today. Did they know that this was up, or did you just make arrangements to come in
This has
today?
been scheduled for approximately 3 weeks.
We need to cancel the warrants if they haven't been canceled, Lisa, too, on these.
Yeah, they have.
All
been.
right. I just don't know anything about it. All right.
The allegation, do you want me to give you a brief summary of the allegation?
Yeah, but give me 1 second.
Sure.
Who was bringing her down, Lisa? I don't
Thought
know
it
where
was
she
Jen
is.
Miklos.
This one. This one.
You know,
This one.
Heather,
No idea.
can you find her, get her in here? Just give me 1 second, will you please? And I'm gonna press it right now. Yeah, now you can give me a brief synopsis, if you would, Mr. Pasha.
Your Honor, the prosecutor's theory of the case is that that Mr. MacArthur, Mr. Robert Joseph MacArthur, and Mr. Robert Nicholas MacArthur were patrons at a Gibraltar establishment. That at some point during the time that they were at this establishment, that there was an altercation between the complainant and Robert Nicholas MacArthur. That Robert Nicholas MacArthur was injured during that encounter, and that ultimately Robert Joseph and Robert Nicholas with some sort of malice and an intent to seek out retribution, thereafter attack this particular complainant. Obviously, we disagree with that, but that is, as alleged, and what I believe to be the prosecutor's theory of the case.
What establishment was this at, Mr. Haysha?
Just one moment, Your Honor. Captain Jim's, Your Honor. I'm not familiar with it, but I believe it to be a local spot.
All right. Okay, here's what I'm going to do. You're asking for a personal bond.
I am.
Any one of these guys have any criminal history?
There's no assault of history for Robert Joseph MacArthur. In 2011, there was a neglect of duty. It was a matter that involved him failing to, it's a very public matter that involved a circuit court judge in Wayne County and a prosecutor, and a neglect of duty for failing to arrest a sitting judge and a sitting prosecutor.
Wait,
that
say
is-
that, say that again?
There was a very public case in 2011 in the Wayne County Circuit Court that involved a criminal defendant that was a circuit court judge. I don't want to put any names out there right now, and a prosecutor. And Mr. MacArthur, while in his capacity in law enforcement, was charged and ultimately pled to neglect of duty for failing to arrest the prosecutor and the judge during the course of that case.
Wow. All right.
That's the sole criminal history. Aside from that, Your Honor, he's been a pillar in the community, coached Little League football, baseball, and basketball in the area of Gibraltar. He was a high school coach for basketball. He owned several businesses and apartment complexes in the Gibraltar area. He's been in law enforcement for longer than I've been alive, with the Sheriff's Department, City of Northville, Inkster, DEA Task Force, Highland Park. He was a City of Detroit transit officer. He doesn't represent a danger to the community or a flight risk.
Who's he work for now?
He's currently working security, Your Honor. He has two positions that he works for in the state of Florida.
And is he required to carry a firearm?
As a condition of work, Robert, do you carry a firearm as a condition of your employment?
I do, sir. I currently hold a Class G license, and I do work in a school.
School resource officer. I apologize, Your Honor.
And I also work for my church as a security officer for the church that I attend.
Okay. All right, look. So much paperwork to fill out. Here's what I'm doing. I'm gonna give you both a personal bond of $5,000. You can leave the state. You can remain in Florida. You cannot violate any law or ordinance. You must appear in court as directed. Neither one of you are to have any contact with James L. King III. No contact with him. You cannot write, phone, see, text, email him, communicate with him, or have any contact with him whatsoever. You're not to have any contact at all. No contact at all with prosecution witnesses except through your lawyer. No contact with prosecution witnesses except through your lawyer. You are not to enter the property address at 29104 North Gibraltar Road in Gibraltar. You're not to go back there. You're not to possess any firearms or dangerous weapons. No firearms, no dangerous weapons. I'm going to allow you to continue to use those, except when working, Mr. MacArthur. So I'm going to trust that you have a place to keep that
I do, sir.
firearm on the premises because you're not going to take it out of there. Do we understand that?
Premises, referring to where I work.
Wherever you're working in law in your capacity that requires you to carry a firearm, I'll let you continue to do that. I'm not going to take your job from you effectively by saying you can't use a firearm, but I want you to store it somewhere. I don't want it in your possession except in the course of employment. Do you understand that?
Yes, sir. I understand fully, sir. Thank
And
you.
as for you, that's Robert Joseph. And as for you, Robert Nicholas, you're not to possess any firearms or dangerous weapons whatsoever. I'm going to ask that I'm going to have you return to the Gibraltar Police Department to be fingerprinted and photographed by June the 23rd. I will let you appear by Zoom. If you can work this out differently, Mr. Haysha, I could care less. You know, if you can, I don't think they're going to be able to do what you're suggesting is what I'm trying to tell you nicely. So I'm going to give them 2 weeks to get here. If you get the fingerprinting somehow done where they're here in Gibraltar by two weeks from now, and you should call Detective Robinson on that, I'll be more than happy. I'm not looking to make people travel across the country, but that's what I'm going to have here. Okay. So
Noted,
give
Your
me a
Honor.
court date if you would, Lisa, and we'll go from there.
June 23rd at 8:45.
I just want to make sure because I don't see that. Have they been canceled? Have the warrants been canceled?
Yes.
Okay, good. June 23rd at 8:45. Is that good with you?